along with you because you're actually, you know, making $20, $25 or whatever, drawing.
Be addressed because that with that to begin with, you know, as soon as um, those lawsuits came through, I'm like, that's setting a very dangerous precedent because for a lot of artists, that's what they do, you know. And I've been trying to tell some, you know, hey, don't even bother because it's not even worth it. Because at any given point in time, you know, all they gotta do is say stop, and you've got to stop. There, you know, there's nothing you can really do to protect yourself. And speaking of trademarks and copyrights, what for a publisher just starting out and they got some idea of what the process is, what is the best way they can trademark their properties and copyright without a whole lot of expense?
Well, the thing that I usually suggest to independent artists is to focus on the copyright first and the trademark second.
Mm-hmm.
Because what happens is the story is actually, and the concept of your characters is the thing that is actually the cheapest to actually protect,
mm-hmm.
and it is probably the more important piece. Because if the thing is, you're not really going to worry about, as an artist or a writer, you're not really going to worry about your trademark until it comes to a point where you actually want to license that out for some
mm-hmm.
kind of merchandising deal, or you want to actually package that as a larger thing to actually sell to a third party or license to a third party.
Right.
So, and because it costs several $100s to actually file a federal trademark,
mm-hmm.
and it only costs maybe $20, $30 to file a copyright, and you can do all of this online.
Uh-huh.
I would say when you're actually ready to put out a book,
right,
before you do the solicitation of the book,
uh-huh.
go onto the copyright office website,
uh-huh.
register the copyright for your work.
mm-hmm.
It's only going to cost you a few dollars. If you already have a business set up, those copyright filing fees are actually tax deductible.
Right.
And just hold on to the documentation. You've got the copyright filed,
mm-hmm.
and everything is fine.
Okay.
Now, once you actually, you know, if you've had 25, 30 issues of your book come out, you've got the account set up at Comixology, you have a certain amount of revenue coming in,
mm-hmm.
maybe one of the first things you want to do with that extra revenue, once you've covered your basic costs, go ahead, file a trademark.
mm-hmm.
A trademark also takes much longer to file anyway.
Right.
And it could be, depending on the property that you have, filing a trademark might be less important. I mean, if you take a book like, I don't know, Road to Perdition or A History of Violence,
okay,
there's really no major trademarked image that's actually associated with those comics. So in that case, file a copyright,
mm-hmm.
worry about it. Now, if you have, like, if your book is based off, there's major symbolism, like the guy has a spider on his chest or a bat on his chest, and he probably shouldn't have either one of those things.
Right.
That's into trouble. But if there is some kind of image or symbol that you've already thought, well, okay, this is actually associated with the book, and later on, this can go on a coffee mug or
right.
sheets or whatever,
mm-hmm.
then okay, go ahead and file the trademark.
Right.
Make sure you do the copyright first and do the trademark later when you have extra money to work with.
Okay, gotcha. Now, with going forward here, now there have been discussions about copyrights and everything else. And a lot of the, aside from going through formal channels, a lot of people say, the law, from what I've understood, just reading bits and pieces of it, as soon as you create a written work, there's supposed to be a quote unquote automatic copyright. But I understand it goes a little bit further than that. And then some people say, well, all you gotta do is put a copyright on there. I'm like, okay, yeah, true. But what kind of defense? Let's just say, for example, we wrote out a script and for a book, and then we got the book actually published without going through all that formal, without going through the formal process of actually formalizing going through the copyright office and going through all that paperwork, and then all of a sudden somebody turns around and comes up with the same thing, and we say, well, wait a minute, we've got this, and what would a judge or any kind of jury say to that? Because I know there's a lot of people say all you gotta do is put a CNTM and you got certain rights, but would a court of law actually recognize those rights as first and prominent versus the person who goes through all the go through the legal process to get a actual copyright?
Well, the difference between, because now the people who've actually said, once you actually, and the legal term for it is to create a intellectual work in a fixed medium of expression. So basically you take a computer program like Word and you type out your script for your book. Once you do that, you have in fact created a copyright in that work. The difference with actually filing is it's much easier to enforce your rights, and the courts and the arbitration panels and everyone else who actually looks at these things, they actually make certain automatic presumptions when you filed, and there's much fewer legal hurdles that you have to go through to actually prove that you own whatever story or image you created. And if you actually wrote the story on your computer and then, I guess, released it, or you sent it out to people as like a spec script or whatever, and then tried to claim later, there's a much more complicated and much more expensive discovery process if you don't already have the registered copyright. So what I tell my clients is it'll cost you a little bit up front, but it will save you, if you run into a problem, a lot more money later on. Like they're talking about the difference between spending $50, $60 for a particular graphic, the issues of a particular graphic novel, to buy copyright up front, or $5,000, $10,000, $15,000 to go through the discovery process to prove that you did the thing in the first place.
Got you. So in other words, it turns out being just like the old commercial. You could pay for it now, or you could pay for it later.
Exactly.
Okay.
Later, it'd be a lot more.
Right. Oh, I could just imagine. So now, then, with the going forward from there with the trademark and the licensing, and this is where I want to pick your brain even really good, because one of the reasons I believe I understood reading about Marvel becoming Marvel Entertainment is that when the last little bit of the reboot for Spider-Man and everything, Marvel really wasn't liking what Sony was doing, and they were just like, and basically they were saying no, and Sony's like, well, it's you can't stop us because you've already sold off on the rights and everything else, and all Marvel could do was just sit there and stew and watch everything watch everything go down the tubes. Then they find then all of a sudden, some kind of way, they got the brilliant idea, well, if we can, better yet, instead of having somebody else do it, we'll just do it ourselves. It became Marvel Entertainment. So with these contracts, especially now with the slightest little thing becoming the next thing, either on a big screen or in a virtual screen, how how can a publisher still have that last say so over how their product's being presented? Because let's face it, that image, especially for those folks who don't look at comic books, that's going to be the image that's going to be burned in somebody's brain. So what can a publisher do in order to protect the future of their image?
Well, let me answer that question in two parts.
Okay.
Because the Marvel situation was a rather unique situation when you're talking about licensing, because at the point that Marvel licensed properties like Spider-Man, X-Men, Hulk, Daredevil, what they were trying to do was generate revenue because Marvel had declared bankruptcy.
Right.
And they were trying to actually generate some revenue just so they can keep the lights on.
Okay.
When they did those deals, they were in a very poor negotiating position, and they basically gave, at that point, Marvel had these things called, well, it's basically the same concept. There was the X-Men universe, the Spider-Man universe, the Daredevil universe, and when somebody like Sony came in and they got the Spider-Man universe, they got every character that was associated with Spider-Man comics traditionally. So whether that's Rhino or Aunt May or Electro or whatever, but it's not going to cover somebody like Galactus, because Galactus was not in Spider-Man comics.
Right.
Now, fast forward to maybe 2002, 2003, Marvel comes out of bankruptcy. Marvel has enough money to start to make their own movies, and then because part of the treaty, because they understand the character and the process better, they were able to make better movies. Meanwhile, the places that they licensed the films to, most notably Fox, who couldn't really wrap their head around Hulk or Daredevil or things like that, those movies started to fail. When those movies started to fail, the studios realized, well, we could actually, the way those licenses work, it's kind of like if you keep using it, you pay the license, which is why you see Fox making an X-Men film every couple of years, because if Fox waits too long, too much time passed, the entire X-Men universe goes back to Marvel.
Okay.
Which is what happened to Daredevil, because they tried Daredevil once and then they gave up and Daredevil went back, to Marvel. Hulk, the same thing. That's how Marvel actually got their properties back. So it was a position, it's a financial situation. When you have a stronger financial position, stronger negotiating position, you could actually get your properties back. So the way the Spider-Man deal worked was a little bit different, because Spider-Man, they actually formed a separate company. It's called Spider-Man Pictures Limited or something. But that company is 50% owned by Sony, 50% owned by Marvel. So they had to actually massage it much more to actually get Spider-Man to come back into the what's now called the Marvel Cinematic Universe, but at the same time still be a Sony property, because Sony still has 50% control over the movie version of Spider-Man. Now, the second part of your question is how does the publisher actually protect themselves from, well, in controlling how the image is actually displayed. That relies a lot on how strong your negotiating position is when the deal gets made, because there's certain types of approval that a creator can have. You could get what's called consultation, which basically just means the studio is going to tell you what they're going to do, and you don't have any say in the matter.
Right.
But then there is what's called final approval, where nothing can actually happen in the story or in the imagery or in the storyboards until you approve it.
Right.
There's two specific examples that I can think of where you can actually see the difference. Whether you're talking about Fox's representation of Ghost Rider, the Cage movies, Marvel did not have final approval over how that was actually displayed, so they didn't have any control over what happened with that movie. But something like a 300 or Sin City, Frank Miller had final approval almost every aspect of the film. So nothing happened until Frank Miller said it could happen. movie actually looks the way it does.
And then from there you could see the difference off the top in box office revenue. So that's very that to me is even better than creative control, because I mean, because to me that even comes down to the casting, because let's face it, there is in certain X-Men movies, certain characters that were cast as certain people were, I'm still head scratching. I am thoroughly head scratching, and I'm just like, really? I mean, the only character to me out of that whole franchise that made it work was Hugh Jackman as Wolverine.
Well, now, okay, but wait. Now
Okay.
we're going off on a tangent now. But who else were they going to get to play Professor X?
That's true. You know what? I agree with you on there. Yeah, Patrick Stewart as Professor X. Yeah, there could have been nobody else realistically that could actually pull that off. So yeah, with that, yeah, I thoroughly agree. Patrick Stewart as Professor X. Yeah, I mean, you could actually try some other names, but realistically, with he already has that persona as a leader from Star Trek: The Next Generation. So to me, yeah, that was a no brainer. And realistic, if it were me running the show for Wolverine before he passed away, the one of the first people that came to my mind was the professional wrestler Chris Benoit.
But can he act? That's the thing.
He's a professional wrestler. They know how to act. Believe me, I've been there.
Wait,
So then now going a little bit forward. So now with the third party, because for me and our little company, Kiss Me Comics, I'm waiting to hear those match. I'm looking to where we get to that point, and people see the potential, and in order I for us we want we want to hear, well, actually we want to present those the magic words third party licensing, because to me, that's where the money is. Just like you said, Marvel can take they could take just about any symbol within their universe, put it on underwear, in which they have, and anywhere else, and bring in that revenue. So, and then from there, and with those trademarks. So would it be smart for a up and coming publisher to go through the due diligence, and then once that it moment happens, still, like you said, they still hold on to the copyright, but instead of going full board and grabbing the money, would it be smarter for them to go third-party licensing with royalty payments?
What you have to actually take a look at when you have a potential merchandising deal, and before I go into merchandising, let me just say that it's very difficult to set up a merchandising program with a property that does not already have an established following.
Uh-huh.
The reason why you have so many huge merchandising programs for Guardians of the Galaxy now is because the movie was so big. There was no licensing for Guardians of the Galaxy before the movie, because nobody knew what the hell a Groot was. Buy a Groot toy, so they didn't have no idea. Right? So you want to actually set up your merchandising program after you have a groundswell of popularity for your character.
Mm-hmm.
It doesn't necessarily have to be like a major movie.
Mm-hmm.
This could be from just a YouTube channel. It could be just purely from comic book sales.
Right.
But you want to have a following first.
Mm-hmm.
Now, the way payments, there's several different types of payments that can be done with any license.
Right.
There's something called an advance, where you actually get a certain amount of money in anticipation of a certain number of units of your whatever it is being sold.
Right.
Let's say we're talking about T-shirts, and the deal says you're going to get $2 a T-shirt.
Mm-hmm.
Well, they might give you, depending on how you negotiate it, $1,000 up front if they assume they're going to sell at least 500 t-shirts.
Right.
So you get in advance.
Mm-hmm.
Now, there's another type of payment that's called a minimum guarantee, which means you get a certain amount of money up front, no matter how many shirts they sell.
Right.
So let's say they give you $5,000 for your license, but they only sell, and you get $2 a shirt. Right. They only sell 1,000 shirts. So they only actually generated $1,000. They already paid you $5,000. So it has not that becomes their lost $4,000. It has nothing to do with you.
Right. Gotcha.
The royalty payment is basically what we're talking about. How much per unit you get
mm-hmm.
for everything sold. But if the shirt costs $20 and they give you 10%, you get $2 a shirt.
Right. Gotcha.
Now, if there's some deals, like when I was working in Marvel, we actually set up deals where people were giving us minimum guarantees and royalties.
Mm-hmm.
And there was all kinds of penalty payments set up. There was it was actually a Marvel license, and I'm assuming a DC license works the same way,
mm-hmm.
actually structured to be far more complicated with a lot more moving parts
mm-hmm.
and a lot more control by whoever owns it, because the other thing you want to actually take a look at is who's selling your stuff,
right.
what's selling, and where they're selling it.
Right.
Give t-shirt, let's stick with the t-shirt example. I can give you t-shirt rights, and I can tell you could sell these t-shirts in the United States, Canada, and Mexico.
Uh-huh.
That's it.
Mm-hmm.
Then I can go over to London and I can sell the same t-shirt rights. And I can tell them, well, you can sell that in Europe and North Africa.
Mm-hmm.
Get on another plane, go over to Hong Kong and say, look, you could sell these same t-shirts.
Mm-hmm.
China, Japan, South Korea, Thailand.
Right.
And you can keep doing this. And if you want, and in certain situations, Marvel does this, they have a different license for the same thing.
Right.
In 165 different countries.
Mm-hmm. Yeah.
And that is the power of a trademark, because now you're selling this stuff in South Africa, you're
right.
selling it in Egypt, you're mm-hmm. selling it, and the money's coming in from everywhere.
Right, exactly.
And you make a lot more money doing that than you do actually selling the comic book.
Right.
Where they came from.
Mm-hmm. Exactly. Like I said, for me, that's why one of the reasons I'm looking forward to hearing, getting to that point to say, yeah, third-party licensing, because then that way you can dole out bits and pieces. Now, sitting back just listening to you about trademarks and everything, I have a very, very good question here. And this is going back to conventions and cosplayers. Now, how would you, as an attorney, interpret cosplayers dressing up in the image of a trademark character by one of the major publishers? Is that or is that not infringement?
Well, on a certain level, yes, and on a certain level, no. But I believe both the most major players, whether you talk about comic book characters, video game characters, movie characters, whatever.
Mm-hmm.
It is technically not infringement, I don't believe, because there's actually no revenue, unless you're talking about the people who win $500 at the cosplay contest.
Okay.
There's no actual revenue for the company to say, you took that money from me.
Right.
The company itself is going to dress up somebody as Catwoman and Psylocke and send them walking around.
True.
Getting a picture taken. And those pictures being taken is not actually injuring anyone who owns the copyright.
Uh-huh.
That's how it's different than you drawing an image and then selling that image. You just made some money.
Okay.
The cosplayer, I believe, depending on how elaborate the costume is probably losing money.
Okay.
Because they set the costume up and
mm-hmm.
they would take pictures and all that. But because so that's the first thing.
Mm-hmm.
The company's not losing any money, so it's not really worth it to go after the cosplayer. The other thing is the cosplayers actually serve as an advertising for the character.
Right.
Every time you see Joker walking through the Comic-Con,
mm-hmm.
like, Joker's cool, which when you get to the show floor and you see the Joker poster and the Joker comic book,
Mm-hmm.
you go, well, Joker's clearly popular because everybody's dressed up as Joker. Let me buy this book.
Right.
It actually works for the advertiser.
Mm-hmm.
There's a reason for them to be chasing down people dressed up as Joker and telling them, take that off, that's an infringement. It's not worth it.
Okay.
So that's how the cosplayer is different from the guy in Artist Alley who's actually doing commissions and making cash. Okay.
Okay, and for those of you out there who are going to be at C2E2 coming up in a few weeks, be forewarned. Know your P's and Q's and dot your I's and cross your T's. You know, so now with international, you know, and especially nowadays with everything going digital, and now with pretty much anybody anywhere can read anybody's work. Okay, so what can a publisher do in order, and I'm speaking from experience because a lot of times I get occasional stuff from companies from China and all over talking about, well, you know what, your domain blah 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 is here and so on and so forth. What can a publisher do on an international scale to protect their work?
Well, it is because, well, there's two things.
Mm-hmm.
One, you have to think about the format and the actual way that your books are being distributed.
Mm-hmm.
Because if you're going through certain companies, like if you're publishing through Amazon and you're publishing through like Comixology, they have digital rights management built into their system. So they have a technological way of preventing unauthorized people to a large extent from getting to your work. That's the first thing.
Okay.
The second thing is you have to actually think about what your actual loss is from a business standpoint, and how much it would actually protect you, how much it would cost you to protect yourself from that loss. So let's say, for instance, you find out that there's 3 people illegally downloaded your book in Germany and are reading it illegally. Okay. Now, it might cost that you might have lost those three sales. You know, you might have lost $10. It might actually cost you in terms of hiring somebody to actually track infringements, hiring somebody to send a cease and desist letter in German, getting a German agent to actually take care of it, get some kind of digital rights management of your own outside of Comixology and Amazon to actually protect your rights. And you realize, you know what? It has actually cost me $2,000. It's $10. I should have probably just
let
And also, a lot of times, if you're an independent artist and you're just starting out, infringement is less of a problem than underexposure.
Okay.
If no one knows about your stuff, that is actually probably hurting you more as an independent than people actually hunting your stuff down and taking it. The vast majority of people, even when stuff is online, when you're talking about BitTorrents and all this other stuff, the vast majority of people, if they want your stuff, they will buy it. Especially to make it easy to find.
Okay. Gotcha. Yeah.
So look at how much money you actually have to spend to protect yourself, and then actually ask yourself, how much do you really need to protect yourself? Because in a lot of countries, let's say for the German example, if your book's not in German, people in Germany are not going to try to steal it because they're trying to steal something they can't read.
Okay.
So in a lot of cases, it's not really worth it from a financial perspective to protect the legal rights you have now. If you later on do a German deal, then it becomes much more important to go out and protect your rights in Germany. But then you're actually working with a revenue stream. Somebody actually paid you money for those rights. So okay, I can take some of this money, protect my rights in Germany to actually increase the value of the property. But when you're just starting out, you don't really probably have a lot of money or want to throw a lot of money into that kind of digital rights management when those kind of protections are already out there for creators.
Okay. So, and